The next matter to come before the court this morning is Nathan Suter et al. Versus Hojatollah Karimian. Please forgive me if I did not pronounce that correctly. Both sides will have 15 minutes to argue. The appellant may reserve up to 5 minutes for rebuttal. If you're the appellant and wish to reserve that time, let me know. I'm keeping the clock this morning. We've read the briefs and we are ready to proceed when you are.
Thank you, Your Honors. My name is Paul Flowers. I represent the plaintiff appellants, Mary and Nathan Suter. I'd like to reserve 3 minutes for rebuttal. I'm going to apologize in advance if I'm a little off my game this morning. My plan was to have breakfast down in the atrium. This is my tradition, but they've closed the cafeteria on me, so I'm going to muddle through as best I can here on an empty stomach.
I thought you were going to give the proverbial snow excuse.
This morning was glare. The glare was bad, not so much the snow. Let me start by just saying that we're here on a Rule 12b-6 dismissal, so the review is at de novo by this court. Let me just briefly give the court the procedural background of this malpractice action. We had the complaint originally filed on May 27, 2010, and it named Dr. Karimian and Akron General Hospital as the defendants. As was the clerk's practice at the time, the complaint was served on both defendants by Federal Express, and there's receipts indicating that both defendants at least received it. An answer is filed shortly thereafter that does raise the failure of service defense. We've got some motion practice. An amended complaint is then filed, and Dr. Shapiro and then several other defendants are brought in at that point in time. That's in 2011. Dr. Shapiro files a motion to dismiss. There's rulings back and forth, but the important thing about the ruling that came out on January 2nd, 2013 is that Judge Gallagher held that the complaint against Dr. Shapiro was timely, even though he'd been brought in late in the game, because Mr. Suter, the plaintiff, was of unsound mind. From the time his cause of action accrued until that moment, he had severe neurological deficits as a result of his stroke. So the court held it's timely as to Dr. Shapiro because for that reason. We get another amendment, a lot more practice, and it's not until May of 2013 that Dr. Karimian files his motion for the judgment on the pleadings, arguing for the first time that 3 years earlier he had not been properly served by Federal Express. This motion was originally denied by Judge Gallagher. He issues a ruling and he basically says service was flawed at that point because Federal Express wasn't authorized by the rule, but I'm very reluctant to dismiss this, just reserve them. Plaintiff's counsel doesn't reserve that complaint because it doesn't make any sense. It's way past the deadline, so reservice isn't going to cure anything. When that deadline goes by, Dr. Karimian files a motion to dismiss for lack of personal jurisdiction, making the same argument that he had never been properly served in 2010. This time, Judge Gallagher grants the request. He writes a very candid opinion, in my view, where he says he's very reluctant to do this. He says the plaintiffs are not to blame for this, but it's all a problem with a policy that was developed by this court, or by the Common Police Court standing order, and the clerk's policy of serving by Federal Express. But then he does dismiss the complaint because it wasn't properly served. And then he goes on and says the dismissal is going to be with prejudice because now you can't meet the statute of limitations, so I'm just going to wipe it all out. That brings us here to this appeal. It strikes me that there's really an easy path through all this, which is through the second assignment of error, so I'm going to start there. And this assignment of error is the one that deals directly with whether or not the Federal Express service was proper and the dismissal was justified. First, it's important to note that the defendant's entire position in this appeal is based upon an inaccuracy that is repeated throughout the brief. That is that we requested the Federal Express service of the complaint, and then they cite the June 15, 2010 return of service for that, and plainly on that document there's nothing indicating the plaintiff's requested service. I personally went through the Common Police file and found nothing indicating that the plaintiffs requested Federal Express service of the complaint. They did later request Federal Express service of the amended complaint, that doesn't concern Dr. Karimian and it's late in the game, but as the complaint, that's just not true. It was the
Does that
court.
matter legally?
I think it sets the posture, because there's nothing here you could say is the plaintiff's fault, and that's what Judge Gallagher was really concerned with. You know,
Right, and he didn't find that plaintiff was at fault except for not making service at the time that the court said, I'm giving you another chance to make.
Right, and then he says in his second order, the one we're here on, he says, but that was irrelevant, you know, looking back on it, because it would have been too late anyway. You know, so and he's absolutely right about that. I mean, if they're right, this case should have been dismissed in 2011, you know, 1 year after service wasn't perfected. So yeah,
Well,
I agree with you.
Had been asked to do so, right?
Right. Yeah, that's the thing is, you know, the reason that we're still alive is we had this rule change in 2012. You know, if they'd asked to dismiss before that, we got big problems. But in any event, they didn't. They waited until 2013. But just to go back to your original statement, I agree with you. It doesn't really matter who's at fault. The real issue here is the Hubiak case. And that's what I said, the easy path. I think that's where this can be pretty quickly decided. Hubiak is the decision that this court released last year in 2014, and everyone agrees. It's the same facts. I mean, they agree, we agree, it's all the same facts. You have a medical malpractice case, multiple defendants, they're all served by Federal Express. What happens is you get 3 classes of defendants. 2 of them preserved the service defense in their answer. So that's Ohio Family and Akron Radiology. The 3rd defendants, which are Summit Ophthalmology, they didn't preserve the defense in their answer. The trial judge still dismisses the claims as to everyone, saying that the Federal Express service wasn't proper. On appeal, this court says, first of all, the Summit Ophthalmology defendants didn't preserve the answer, they waived it, they shouldn't have been dismissed. And then when they get to the other 2 defendants who didn't preserve it, the court says, this rule amendment, the 2012 amendment, applies retroactively. It applies retroactively to pending cases, to all further proceedings in pending cases. They didn't file their motions to dismiss until after the rule amendment. The case was pending, certainly as to the defendants who had waived service. Since it's pending, the rule amendment applies to everyone. So Judge Gallagher below is misled down this path of a misinterpretation of Hubiak as some sort of victory for the defendants. When it isn't, all the defendants lose in Hubiak. All the defendants go back to the trial court, and all the defendants are now trying to get Hubiak into the Supreme Court. You know, nobody won there. It didn't matter whether they preserved the answer or not. It didn't matter whether they moved for dismissal or not. They all moved after the amendment. The case was pending. The amendments applied to their motions, and because the amendments applied to the motions, Federal Express service pre-amendment was proper, and that's the same result here.
But the judge took the position that the case was not pending as to Dr. Karimian
Correct.
because he was not served properly.
Correct. And then the Hubiak rejects that, because that's the exact same position that Ohio Family and Akron Radiology were. They preserved the defense, they filed their motion, but it didn't matter because the case is pending as to everybody or not at all. So all you need is one defendant. And in Hubiak, the defendant was the Summit Ophthalmology defendants. They had waived it, so the case is pending. It's pending to everybody. So to put it this way, Judge Moore, if they're right, and if what you're saying is right, the Akron Family and I'm getting my Hubiak defendants mixed up. If that's right, then the defendants, Ohio Family and Akron Radiology, they would have won. Right? They're in the exact same position as Dr. Karimian here. There's no difference. Their argument that the case could be pending as to some but not all, they're trying to get that in the Supreme Court right now. That's their argument for why Hubiak is wrong. Now in this case, They're not arguing Hubiak is wrong. In this case, they take the position that Hubiak is spot on, everyone should follow Hubiak, they've just misinterpreted it. All right, so you can't adopt their interpretation of Hubiak, because if they were right, Ohio Family and Akron Radiology would have won in that case, because their position is no different. And that's, if you look at the briefs they filed in the Hubiak case in the Supreme Court, that's exactly what they're trying to win up there. But the Supreme Court, as far as I know, hasn't taken the case yet. So that's really the easy path. It just comes down to properly interpreting Hubiak. And once you properly interpret it, it becomes obvious that this court adopted the view that we're going to try to resolve all these cases on their merits. We're not going to play these procedural games, particularly when the plaintiffs aren't to blame. And so we're going to hold that this case is pending to everyone as long as you get service on someone. And here, there's no dispute that there was service on Dr. Shapiro, because he waived the defense, exactly the same as Hubiak. Now, Dr. Shapiro didn't put in his answer, didn't move for a dismissal on that basis. The case was pending in early 2013. They filed their motion afterwards, so it's after we have the amendment in 2012, after Dr. Shapiro waives the defense, and the case is pending and the amendment applies. And Dr. Shapiro was just the easy one. There's other defendants in the case who I think also had waived service or accepted service. But Dr. Shapiro actually filed a brief down below where he acknowledged he'd been served. So that's the easy path in the second assignment of error. Just briefly on the third assignment of error, this is the alternative argument if you get to it. The third assignment of error deals with the issue of whether the statute of limitations was told as a result of plaintiff Nathan Suter's unsound mind. And here, this was a surprising ruling because previously Judge Gallagher had said that as to Dr. Shapiro, yes indeed, Nathan Suter was of unsound mind at the time this cause of action accrued. And the finding that it was at the time the cause of action accrued is critical because the statute, 2305.16, has two parts. The first part says it's unsound mind. If you're of unsound mind at the time the claim accrues, that's good enough. You can file when it's removed. The second part is to deal with collusion. And the second part says if the unsound mind arises after the cause of action accrues, you have to be either a judge that or confined in an institution. So the second part's much harder to meet. And then the case everybody always cites in support of this is McKay versus Cutlip, which is out of this court in 1992.
You're just now reaching into your 3 minutes of rebuttal.
Okay, so just to sum up on the third assignment of error, it should have been the same ruling as to both doctors. The cause of action accrued at the same time, which was December of 2008 when the stroke was suffered, not before. So it should have been the same ruling to be of an unsound mind for both of them. Thank you.
May it please the court, Michael Kallenberg for Dr. Karimian. I agree that the issues in this case are entirely procedural and rely mostly upon what this court said 6 or 7 months ago in Hubiak. The history of Hubiak arises out of about 5 decisions from 2012 to 2013 by this court, and the one that is most commonly cited is the Venez decision. In Venez, this court found that if a complaint is served by Federal Express prior to the amendments of the civil rules effective July 1st, 2012, any judgment rendered upon that complaint, provided that the defenses of failure of service are preserved, would be void and void ab initio. And in each of the cases that were cited in our brief are cases where even default judgment was granted and after the fact it was vacated due to improper service. Hubiak takes that one step further, and there is one key distinction here that I think the appellant have glossed over, and I think it's important to highlight, and that is the timing of the filing of the complaint in Hubiak versus the timing of the filing of the complaint in this case. In Hubiak, the complaint was filed on October 27, 2011. That's less than 1 year prior to the effective date of the amendment of the civil rules that give rise to the ability to serve by Federal Express. In this particular case, the complaint of plaintiffs was filed on May 27, 2010. That is actually more than 2 years before the amendments to the civil rules came into play, and we can even get into the discussion of whether or not that can retroactively rescue the complaint on a failed method of service of process. And the reason that's key is because what's provided in Civil Rule 3A, which is upon the filing of the complaint, the plaintiff has precisely 1 year to complete service of process. If they don't, the action is not commenced, it was not attempted to be commenced, and all it takes is a simple filing of a motion. Hubiak, at paragraph 29, specifically acknowledges that there were really only 2 escapes for the plaintiffs in that case. One was that because the complaint was filed less than 1 year before that amendment, the court could use that rule and the change in the rule within that 1 year period to find that service actually had been completed. That was escape number 1. It's not available in this case. Escape number 2 was a waiver of jurisdiction by one of the 3 parties to the initial complaint. In this case, when the complaint was initially filed against the Hart Center, Akron General defendants, and Dr. Karimian, both of them preserved the defense of failure of service of process and lack of personal jurisdiction in that answer. There was not a dispositive motion that was filed prior to the filing of an answer. What that means is any subsequent participation in the litigation having preserved that defense did not waive the ability to raise that defense at any time they so chose prior to trial. I would contend that the reason Hubiak allowed the plaintiffs to come back and the reason it is now being appealed by the defendants in the Supreme Court is because of the issue of waiver, but that waiver issue is not here. To the extent the appellants are now relying upon the waiver as alleged against Dr. Shapiro, that complaint against Dr. Shapiro was filed the amended complaint was filed more than 19 months after this action was filed. At that time, it had not been commenced, it had not been attempted to be commenced, and Civil Rule 3A basically says this is a nullity. Under Venez, any judgment that could be rendered in this case at any time down the line would be void ab initio. And that's the whole point. I think that while I understand that the appellants believe that we are misapplying or misconstruing Hubiak, I think blow by blow, what Hubiak says is, we agree pursuant to Venez that you cannot serve via Federal Express prior to July 1st, 2012. If you did that, the only way you're really out is A, if you can apply retroactively pursuant to Rule 86II, which has to have an action pending at that time, or if someone has waived service. There is no waiver in this case, and Rule 86II doesn't apply because the action was not pending. It had not been served upon either party in a manner authorized by the civil rules, and each party expressly preserved their affirmative defenses of failure of service of process and lack of personal jurisdiction. I don't believe there's any dispute in the record to that whatsoever. And for me, I think it makes it a very simple analysis as to why on that second assignment of error that the assignment of error should be rejected and overruled. As to the third assignment of error on the issue of unsound mind, that issue was decided on a motion to dismiss. While there is reference in their brief, in the appellant's brief, to the issues that were briefed extensively by Dr. Shapiro and the appellants, notably absent from the record is any development of an understanding of when a claim accrued as to the care of Dr. Karimian. Dr. Karimian is a cardiologist who was treating the plaintiff, or the appellant, prior to the hospital admission of the AGMC. And we don't even have to get to these facts because, frankly, the issue in my mind was not preserved for appeal because it wasn't argued. But even if we get there, when he presented to AGMC, he presented with the TIA, a transient ischemic attack. The allegation against Dr. Karimian is that he gave a subtherapeutic dose of Coumadin. And based upon that, the plaintiff was more prone or likely to suffer some type of a stroke type event or a TIA. There is no evidence in the record that can be shown to establish that upon the suffering of that TIA, which they allegedly relate to Dr. Karimian's care, rendered him immediately of unsound mind such that he was continually prevented from the prosecution of his case. Furthermore, if you don't like that argument, the complaint itself, as filed against Dr. Karimian, was filed by Mr. Suter. It wasn't filed through a guardianship. It wasn't filed by a power of attorney. It was brought on his own behalf in 2010. I think it defies some level of credulity to sit here and argue after the fact that unsound mind rescues this case, when in fact, based upon the pleadings that were submitted, he was of sound mind. He filed a complaint on his own behalf. He was able to have the claim investigated by his attorneys and file a lawsuit within the statute of limitations. Problem is that after filing a lawsuit, it was not properly served, it was not properly commenced, and because of that, once the case is dismissed, they do not have the benefit of 2305.19 for the one-year refiling, the savings statute. Without
Were
that,
there references in the complaint as filed that indicated that, or maybe it was in discovery, that indicated that the events occurred before, or that the cause of action basically accrued before the stroke?
so within the complaint itself, there is no express averment as to accrual, but what the complaint actually averred was that Dr. Karimian was treating prior to the admission to AGMC. Dr. Karimian was not, he was not an attending at AGMC, he was not involved in that stroke care. He was a cardiologist just providing doses of Coumadin to manage a clotting condition. But based upon what's in the complaint, there is not enough to conclude unsound mind. And the problem with that is, if appellants are here to argue that unsound mind rescues this complaint, the burden fell exclusively upon them to demonstrate that at all times relevant to Dr. Karimian's care, and any alleged damages that result out of that alleged negligent care, that Mr. Suter was prevented from the time of prosecution of this case from protecting his own personal interests. And the complaint itself, the fact that he filed it on his own behalf, would seem to completely undercut that position. If this complaint had been filed in 2010 through a guardianship of either Melanie Barron's, his daughter, or a power of attorney through his wife, as was subsequently attempted in the First Amendment complaint and the Second Amendment complaint, it might be a different story. That's not what happened. And if, in fact, he's been of unsound mind since 2008, then the complaint itself would have been improperly brought because it would have been brought without the appropriate capacity. Mr. Suter, if he's of unsound mind, he can't file that complaint. He needs someone to do it for him. But that's not what happened. He filed it. So with respect to that argument, I don't think that is a rescue for the complaint. And I think under Hubiak, because of the specific timing of this case and how Rule 3A dovetails with everything that happened in this case and the time that it took to actually recognize and attempt to try and rectify the service failure, the dismissal was appropriate, and certainly the dismissal with prejudice was appropriate, because there was no evidence upon which the court could make any conclusion as to Dr. Karimian. And the reason for that failure is because there's nothing presented. It was the appellant's burden, and it was not satisfied. The reliance upon the ruling as to Dr. Shapiro, it doesn't dovetail. The care is close, the timing is close, but it's not complete. And he has to be continually prevented from prosecution of his own interests and protection of his own interests. And the record just doesn't support that as to Dr. Karimian. Finally, on that unsound mind issue, if the court does want to go into all the filings and the affidavits and evidentiary submissions and depositions that were filed as to Dr. Shapiro's motion, none of the three physicians who rendered testimony either by affidavit or deposition were able to fully establish and competently establish that from December 15, 2008 to the present, that Mr. Suter has been continually prevented from the prosecution of his own interests, that he's relying upon others for all of his care. One of the physicians who only offered an affidavit was his treating physician that did not begin treating him until 2011. The other two physicians that gave depositions, neither one of them had been treating him continually. One had only seen a day in the life video that was taken, I believe, in 2010 or 2011, and the other had basically performed an IME in 2011. None of them had the proper foundation to opine to a reasonable degree of medical certainty that from December 8 to December 15, 2008 to the present, Mr. Suter has been of unsound mind. But for me, that's the secondary argument. The primary argument is that Judge Gallagher, lamentingly so, applied the law that this court has laid down, both in Vanez and in Hubiak. You can't serve by FedEx prior to July 1st, 2012, and if you do, any judgment that's rendered is void ab initio. The only way to get around that is if the parties to that complaint waive. Neither of the parties waived the defenses in the original complaint. More than 1 year passed, and under Rule 3A at that point, it's game over. And, so unless there are further questions from the court, I will yield the rest of my time and ask that the court affirm the judgment of Judge Gallagher below, dismissing the complaint with prejudice.
Thank you.
Well, thank you. I'll be brief. I'm going to start again with the second assignment of error and point out that it is now too late in oral arguments in the Court of Appeals to try to distinguish Hubiak. Maybe I missed it, but I very carefully read all the briefs in the Common Pleas Court. I certainly read their brief in this court. They never once argued Hubiak could be distinguished. To the contrary, page 6 of their brief to this court, first footnote, this court's discussion in Hubiak is directly on point with respect to the lack of personal jurisdiction due to failure of service. Now, I just heard this new argument to distinguish Hubiak for the first time, and I'm not prepared to respond to it. But I think they should be held to their position, which is that Hubiak's right, they just misinterpreted it and talked Judge Gallagher into misinterpreting it. And really, the Supreme Court proceedings don't matter because they're not going to be able to go up there and say, yeah, we didn't agree with Hubiak below, so we get the benefit of whatever happens to Hubiak in the Supreme Court if the Supreme Court takes Hubiak. Their position here is that Hubiak is right, and they should be held to that position. Counsel also made the statement that there was no waiver below. That's untrue. Dr. Shapiro waived the service defense. He did not include it in his answer. He's the same as Summit Ophthalmology and Hubiak. That's why these two cases can't be distinguished, which they acknowledged for a long time, until just recently, until just moments ago. Again, unless I missed it. Hubiak's on point. Hubiak should be followed. Just on the third assignment of error, dealing with the unsound mind, their argument appears to be that we didn't respond, we didn't prove this, because when they raised the issue again, we didn't resubmit all the same record evidence that had been submitted during the first go-around with Dr. Shapiro. That's just not the law. Plaintiff's counsel, in 2 sentences, reminded the trial judge he'd already been through this. There's an affidavit from Dr. Linda Adrig indicating that plaintiff Nathan Suter lost or suffered severe neurological deficits in his stroke, that he will never regain that ability, that he is incapable of managing his personal affairs. That is in the record. There's no rule that says you have to refile an affidavit when a co-defendant raises the same issue. And that's what's mind-boggling, is why Judge Gallagher didn't just reach the same conclusion. But the argument appears to be, well, Dr. Karimian was treating Nathan Suter earlier, so his cause of action accrued earlier. But that's wrong. A cause of action doesn't accrue until there's an injury. You can't sue your doctor just because they committed a mistake. You actually have to have some damages. That didn't occur until we had the stroke in December 15th, and it's the same accrual for both Dr. Shapiro, who came in at that point, and for Dr. Karimian.
And counsel, you have reached the end of your allotted time.
Thank you. So with that, we ask you to reverse the trial judge.
Thank you both for your presentations today. The court will take the matter under advisement and issue a written decision which will be mailed to both sides.